The Second Amendment is likely the most controversial of all constitutional terms. This was one part of what is generally called the Bill of Rights, although these specific words do not appear in the written document. It consists of the 10 amendments passed contemporaneously in December of 1791. The concept of the Second Amendment very likely came from the British Bill of Rights of 1869, which stated on this topic, quote, that the subjects which are Protestants may have arms for their defense, suitable to their conditions as allowed by a law, end of quote. This has since been erased by other legislation in Great Britain. Unlike the United States, there is no written constitution. It is this provision of the Constitution that prevents affirmative government action at the federal and now at the state level from banning weapons such as handguns and arguably even military-grade weapons in the hands of its citizens. Unlike Canada and New Zealand, which did so within weeks following recent mass shootings, the United States has done nothing, which is due to the Second Amendment and its interpretation. The wording is important as the interpretation of the meaning of these words continues to impact life in the United States as we speak. Recently, a California law designed to ban access to all magazines holding more than 10 rounds was declared contrary to this provision, and by recently, I mean last week. The essence of the reasoning was that such an LCM was not an, quote, unusual, quote, form of armaments, as referenced in the case law below. The words of the Second Amendment are as follows: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The essential debate of the meaning of these words is whether the amendment was intended to protect the right of individuals to own arms, or whether this right was intended to apply to militia. This begs the question, of course, as to what militia means. It is not a term used in modern vocabulary. In the time period of the Revolutionary War, a militia was a term for a group of men who banded together to protect their community. This was the 18th century equivalent of the U.S. Armed Forces. There was no professional army. The country relied on these local militia for self-defense. At this time, all males between the ages of 16 and 60 were required to be part of the local militia for their town or community. Many people used and owned guns. Those men who did not own a gun were required to pay a small fee in lieu of participating in their local militia. These military forces defended their towns against Indian raids and also acted as a police force when needed to do so. They were also ready to be called on by state or federal government as required. Subsequently, the Constitutional Convention gave the federal government the right to create an army, even in peacetime. This was a dramatic change in philosophy, as many had feared the use of an army to create oppression amongst the citizens, and that the federal government thus should be allowed to raise an army only to be used against foreign aggression. The militia, of course, no longer exists. It is arguable that the militia was replaced by the National Guard after the Civil War. The debate has ensued now for many years as to whether the amendment was intended to apply only to militia or to a single person. Had the framers intended the Second Amendment to apply to the average citizen, there would be no need to refer to militia in the text. There have been many court decisions on this topic in the modern era. A good reference point is something called the Brady Bill. James Brady was the press secretary for President Ronald Reagan. He was shot on the head by an assassin seeking to kill the president in 1981. Brady became an advocate for gun reform. The law passed in his name requires a prospective buyer of a handgun from a licensed dealer to defer the purchase for 5 business days while the background of the proposed buyer is researched. The bill became law in 1993. The Second Amendment and the 14th Amendment worked together. The question of the interrelationship between the Second and the 14th was whether the Second Amendment applied only to federal laws, or alternatively, was it intended to apply to state or municipal regulations as well. If the law was that the Second Amendment applied only to federal legislation, then the states would be at liberty to impose gun restrictions as they felt necessary. The Supreme Court held, as an illustration of this principle, in 1886, that the Second Amendment applied only to the federal government and could not restrict state action from regulating gun ownership. For example, in the 1886 case Presser versus Illinois, The court held that the Second Amendment applied only to federal government and did not prohibit state governments from regulating an individual's ownership of the use of guns. This was indeed the interpretation until as late as 2010. This arose in a case called District of Columbia versus Heller. It was a watershed case. Prior to this ruling, civilian-owned guns were required to be stored disassembled and unloaded or bound by a locking device. In this case, the District of Columbia had banned handguns by making it a crime to carry an unregistered firearm and also prohibited the registration of handguns. It did allow the chief of police to issue a one-year license. It also required the owners to keep any lawfully owned firearms unloaded and either disassembled or locked. Heller's application to register his handgun had been declined. He sued to declare this law contrary to the Second Amendment. The Supreme Court held in setting aside the D.C. law that the Second Amendment protects an individual's right to possess a firearm without regard to any malicious service. The person can use this firearm for lawful purposes, such as self-defense within his home. Also, the court held that certain restrictions on gun ownership are to be permitted, such as a ban on possession by felons and the mentally ill, or laws forbidding carrying firearms in sensitive places, such as schools or government buildings, or laws imposing conditions on the commercial sale of weapons, all should be valid. The court's prior 1939 decision in a case called U.S. versus Miller declared that sorts of weapons protected are those, quote, in common use at the time, quote, finding support in the historical tradition of prohibiting the carrying of dangerous weapons and unusual weapons. That is, the court in the Miller case held the Second Amendment does not limit the right to keep arms to militia purposes, but rather limits the type of weapon to these used by the militia, that is, those in common use for lawful purposes. The obvious purpose, that's the test, of the Second Amendment was, quote, to assure the continuation and render possible the effectiveness, quote, of the state militia, and that must be interpreted and applied with that end in view. Heller reversed this approach and was a dramatic step in favor of gun ownership interests. However, all was not lost. The court also said that this list, as noted above, was not exhaustive, and the Second Amendment did not necessarily prevent laws banning dangerous and unusual weapons. That might apply to military-grade weapons like M16s. This case was followed in 2010 by a case called McDonald versus Chicago. The case of McDonald was started one day following the court's decision in Heller. The law passed by the city of Chicago and a neighboring town banned the possession of handguns. This case is significant in that it determined that the 14th Amendment was applicable to the Second, which thus made the protections of the Second Amendment relevant to state and municipal laws. The court agreed with the arguments against the city and struck down the prohibition of handgun possession. 25 years ago, Congress passed a law called the Public Safety and Recreational Firearms Use Protection Act, which banned the manufacture or sale of certain automatic weapons and also magazines which allowed for 10 rounds or more. The new law allowed for the grandfathering of those weapons already in possession. There was also a sunset provision by which the prohibition would end after 10 years, barring a new bill by Congress. The bill barely passed in the Senate with 52 votes. The Obama administration attempted to renew this bill following the shootings of young children of Sandy Hook in December of 2012. This bill failed in the Senate. There are other cases allowing limits on gun use. A prohibition on the possession of weapons on government property was upheld in a case called U.S. versus Dorison, in which the defendant was convicted of bringing a handgun onto post office property. A bar on juvenile possession of a firearm was also allowed, which limitation arose from the Juvenile Delinquency Act in a case called U.S. versus Rennie. A New York law which prevented persons from obtaining the required permit to carry a concealed weapon was allowed to stand. The argument made against the law was that a desire to obtain the permit for, quote, general purposes, quote, violated the Second Amendment. With respect to assault weapons, the U.S. Circuit Court of Appeals affirmed the constitutionality of a Maryland ban on military-style 7th-grade semi-automatic weapons and large-capacity magazines. Maryland law banned ownership of assault weapons, the definition of which in the Maryland law included the post-popular semi-automatic rifles, which allow for one bullet per trigger pull without reloading, and also made illegal magazines capable of holding more than 10 bullets. In the reasons for the decision, the Fourth Circuit of Appeals referenced a passage from D.C. versus Heller, which stated that the weapons, quote, most useful in military service, M16 rifles and the like, end of quote, could be banned. From these words, this court concluded the test for whether a class of weapons could be banned was whether such weapons were, quote, like an M16, quote. 9 of the 14 judges who heard the case formed the majority reasons. This raised much controversy and was one of the unsuccessful grounds of review in the Supreme Court appeal. The Supreme Court denied the review petition without reasons. The legal standard accepted by the court was that the state must show that the gun prohibition advances an important state issue by what is referenced as the, quote, intermediate scrutiny, quote, test. There had been some debate previously as to whether the correct test was just that, or, quote, heightened scrutiny, quote. Under the intermediate scrutiny test, the state must show a reasonable, if not perfect, fit between the law and Maryland's interest in protecting public safety. The court, however, also stated that no matter which test was to be used, the legislation was constitutional. The result was that the Second Amendment was interpreted to allow legislation to restrict civilians to own such weapons. This decision was upheld by the Supreme Court of the United States. Presuming this to be the law today, this would empower each state to take steps to ban military-grade weapons. Many have chosen not to do so. There's a decision called Colby, which was one of 4 different circuit court decisions to have upheld state bans on semi-automatic rifles. In Colby, the Fourth Circuit of Appeals held that AR-15 and semi-automatic AK-47 weapons and other banned semi-automatic rifles were not constitutionally protected arms because they are weapons that are most useful in military service. The Second, Seventh, and the D.C. circuits had all held that semi-automatic rifles, while protected by the Second Amendment, were still subject to prohibition by legislation, as such a ban was justified by government interest. It may be noted that in Colby there was a 4-judge dissent. This dissenting opinion was of the view the majority decision was contrary to the Supreme Court decision in Heller, which stated that the protections of the Second Amendment were extended to firearms commonly used for a lawful purpose. The argument in favor of the dissent is that the popularity of lawfully used AR-15s and semi-automatic AK-47s meets the Heller reasoning as being firearms commonly used for a lawful purpose. Colby, viewed in the perspective of Heller and Justice Scalia's decision, held that the Second Amendment allows citizens to own weapons in common use at the time. This decision did note that not every gun meets this definition, and the Second Amendment does not protect weapons not typically possessed by law-abiding citizens. Significantly, these reasons stated that the Second Amendment did not extend to dangerous and unusual weapons, such as weapons which are most useful in military service, M16 rifles and the like. Justice Scalia's decision offered no guidance as to how to determine if a weapon meets this standard of in common use at the time, or alternatively, danger and unusual. Indeed, the plaintiffs in the Maryland case had unsuccessfully argued that semi-automatic weapons were the most popular guns in use, with some 8 million in circulation at the time of the case. The focus of the majority decision in the Maryland controversy came from the words of Justice Scalia, that governments should be allowed to prohibit weapons that are most useful in military service, M16 and the like. The automatic weapons banned in this case were adapted from the M16s and other automatic rifles developed for military use, as was decided by the Fourth Circuit in that case. This then put the banned weapons within the exception of Justice Scalia and Heller. The dissent in the Maryland case concluded that given the prevalence of such weapons in the possession of Americans, that such weapons were protected by the Second Amendment.